Tonight, the Supreme Court blocks the census citizenship question, at least for now, but says political gerrymandering is now okay under the law. So districts that look like this, they're going to get even more twisted, and so will our elections and how our government works. Plus, we run through the winners and losers from night one of the first Democratic debate and also preview round two, which happens in just a couple hours. And later, you may not know the name Luis Alvarez, but you should. The retired NYPD detective, he is dying from cancer he got at Ground Zero, but his gift to Mitch McConnell might save the lives of other Ground Zero victims. We'll share his heartbreaking story tonight. Good evening and welcome to RFL. I'm Richard French. Well, the Supreme Court has spoken on the biggest cases of its session. They blocked the use of a citizenship question on the court, at least for now. But in a 5-4 ruling, all on ideological lines, the court, they allowed political gerrymandering. They said the federal courts had no right to stop or block it, a change that will likely make our politics even more partisan and lead to even more gridlock if that's possible. Now, at this point, you may be asking, what exactly is gerrymandering? Glad you asked. That's when after every census, every decade, state lawmakers redraw the districts for federal and state offices in whichever way they choose, often having nothing to do with geography, so they end up looking something like this. Now, in the two cases that the court ruled on, lawmakers, they ripped up their maps to give one party clear advantages on Election Day and even admitted that's why they did in the first place. Now, whether it's fair to voters or not. And the High Court today said, go right ahead, make them even worse if you choose. State courts and Congress can pass restrictions if they want, and this same court just ruled that gerrymandering for race, that is illegal. But federal courts now have no say in political gerrymandering. Now, Chief Justice John Roberts, he wrote for the majority opinion, saying in part, quote, we conclude that partisan gerrymandering claims present political questions beyond the reach of the federal courts. Federal judges have no license to reallocate political power between the two major political parties with no plausible grant of authority in the Constitution and no legal standards to limit and direct their decisions, end quote. As for the four liberals who voted against the majority decision, Justice Elena Kagan, she wrote for the dissent, and she read part of it from the bench this morning, the highest profile way of showing her anger over the decision. Kagan began, for the first time ever, this court refuses to remedy a constitutional violation because it thinks the task beyond judicial capabilities, and not just any constitutional violation. The partisan gerrymanders in this case, or in these cases, deprive citizens of the most fundamental of their constitutional rights, the rights to participate equally in the political process, to join with others to advance political beliefs, and to choose their political representatives. In so doing, the partisan gerrymanders here debased and dishonored our democracy, turning upside down the core American ideal that all governmental power derives from the people. These gerrymanders enabled politicians to entrench themselves in office as against voters' preferences. They promoted partisanship above respect for the popular will. They encouraged a politics of polarization and dysfunction. If left unchecked, she continued, gerrymanders like the ones here may irreparably damage our system of government, and checking them is not beyond the courts. The majority's abdication comes just when courts across the country, including those below, have coalesced around manageable judicial standards to resolve partisan gerrymandering claims. And she concluded by saying, of all times to abandon the court's duty to declare the law, this was not the one. The practices challenged in these cases imperil our system of government. Part of the court's role in that system is to defend its foundations. None is more important than free and fair elections. With respect but deep sadness, I dissent. Now, as for the Census Citizenship case, the court, they did block the Commerce Department from adding that question, at least for now. It's unclear if the Trump administration can still add it, and the White House is asking if the census, can in fact be delayed. For more, let's bring in our guest, Garrett Epps. Garrett is a professor of law at the University of Baltimore and a contributing editor and Supreme Court correspondent for The Atlantic Online. Garrett, thank you for the time. I appreciate it.
I'm glad to be here.
I read a longer version than normal of a justice's argument, in this case for the dissent, but I thought it was necessary for the context because in Supreme Courtese, for Kagan to both speak audibly and to really with the directness that she chose is not common. Do you think she was right?
Yes, I do. I think that there's a disingenuousness about the majority opinion by Chief Justice Roberts, in which he acts as if there's no possible way to catch any partisan gerrymanders that go too far. And he basically recharacterizes what the plaintiffs in this case were asking for, saying they want a constitutional right to have the number of representatives that equals their proportion of the vote. That's simply not the case. That's not what they were asking. What they were saying was, if you look at a statewide vote and you find out that one party gets, and this does happen, one party gets 60% of the vote and receives 40% of the seats in the legislature, that may be a sign that there's been intentional partisan gerrymandering. And if it passes beyond a certain point, it's a constitutional violation. It's a violation of the Elections Clause. It's a violation of the First Amendment. Now, the court has never had 5 justices agree on what the test should be. This was their opportunity to do that. It became clear when oral argument was heard that the court was going to divide on partisan lines, and I don't think anybody is very surprised that the 5 Republican appointees have given their green light to gerrymandering that entrenches legislative majorities, because the Republican Party has been the most aggressive practitioner of this particular kind of gerrymandering.
Garrett, I have some practical questions about how this is applied, because it seemed that the court had a choice. Once you had the North Carolina lawmakers on record saying that they were reconstructing the map and it was 10-3 Republican to Democrat, but they would have made it 11-2. They just couldn't figure out a way to, basically screw the Democrats out of a seat. They said that nakedly. The court then has it. They have, if you will, the motive. The court also ruled that you can't gerrymander on racial lines. So if they've got a standard where it's a bridge too far, and they know the motivation isn't to respect the rights of the voters, if you will, they could have punted theoretically. They didn't have to do what they did, and it certainly wasn't consistent with prior rulings. I just don't follow.
I think it's, I think the realistic explanation is actually not complicated. The justices, the conservative justices, expressed discomfort during oral argument at the idea of appeals coming to the court from districting decisions in all the states. They didn't want to be involved in that. And so they decided that these are what we call non-justiciable. There simply is no law. They didn't say that the legislators in North Carolina were not acting for partisan motives. They said, Roberts quotes that quote that you mentioned. He just says politics has to be part of this process, and that's the way the framers wanted it, and so forth.
In effect, Justice Roberts said, it's not our job. And for a more simplistic question, isn't it, if it's not the Supreme Court's job, whose is it?
I think Justice Kagan makes a fair argument when she says that the Supreme Court is charged with enforcing all parts of the Constitution, the Elections Clause, the Equal Protection Clause, the First Amendment, and simply to say there's no text in the Constitution that gives us, the court, responsibility for apportionment. It's disingenuous. It doesn't pass the laugh test. And I finally would say that if you're in the market for a used car, I wouldn't buy one from the Chief Justice. He has the straightest face in American law.
What, if anything, do you read from this in terms of, with this current court, and obviously the questions about how willing they might be to upend stare decisis, how willing they may be to be activist? Obviously, Roe v. Wade, affirmative action, those things are on the horizon potentially for future sessions. Can you take anything away from today that gives you a read as to where they may go?
No, because neither of the big cases today were governed by stare decisis. The court had never decided this question of what is the test for partisan gerrymandering. The court had never decided the question of whether the government was allowed to include a citizenship clause on the census form. And so they didn't have to overturn any precedents, right? Now, the fascinating thing about the end of this term is that having overturned a number of precedents quite blithely in March and April and May, the court did not quite slash and burn quite as much as they were expected to do this time. But I think you can see, and if you read the separate opinions in these cases, you can see a real hunger and impatience by the justices on the far right. And by that I mean Justice Thomas, Justice Gorsuch, and Justice Alito, to just say, let's get on with it. We have the votes. We don't have to put up with this nonsense anymore. Let's ram our program through. Chief Justice Roberts is reluctant to do that. I don't want to try to pretend to see into the man's mind, but I don't think he ideologically disagrees with the far right wing of his court. I think he thinks that defending the court's so-called legitimacy in American politics means that they should move slowly rather than quickly. But I do think the court has launched itself. We know where it's going. It's going to the right. The only question is how far and how fast.
Well, a very interesting day, Garrett, and I have a feeling we got more to come with this court. Thank you so much for a few. I appreciate it.
I enjoyed it.
All right, everybody, so you got the legal analysis now of today's Supreme Court rulings, but these cases have huge political impacts as well, one that could influence politics for a decade or even far, far longer. We come back. We're going to talk politics with longtime California Senator Barbara Boxer, not just the High Court. We'll also get into that really heartbreaking photo of that father and daughter that have died in the Rio Grande and where we are right now with these child detention centers and more. Stay with us.